The United States Department of Justice just released a settlement agreement with Ripple XRP. The government enters into this settlement agreement based on the specific facts and circumstances presented by this case and the company. The United States Attorney's Office in the Northern District of California will not criminally prosecute Ripple XRP, a Delaware corporation with its headquarters located in San Francisco, California, and any and all of its subsidiaries, collectively Ripple Labs, or the company, for any of the conduct detailed in the statement of facts, attached as attachment. The following were some of the factors taken into consideration: the company's long-standing cooperation with the government, the company's pledge to maintain and improve its internal controls, training, and anti-money laundering program as outlined in attachment, the company's agreement to move a portion of its operations as outlined in attachment, the company's commitment to cooperate with the government in any ongoing investigations regarding the conduct of the company and its officers, directors, employees, agents, and consultants in relation to violations of the Bank Secrecy Act. The government certifies that it will not file a criminal or civil lawsuit against the company for any of the actions outlined in the Statement of Facts, which is included to this agreement as Attachment A. But the government may use any information about the actions detailed in the Statement of Facts that is attached against the company in the following ways: in a prosecution for perjury or obstruction of justice, in a prosecution for making a false statement, in a prosecution or other proceeding pertaining to a violent crime, or in a prosecution or other proceeding pertaining to a violation of any provision of Title 26 of the United States Code. All of these prosecutions and other proceedings must, however, be unrelated to any potentially obstructive actions that the company disclosed to the government before the agreement was signed. There is no defense against prosecution for any actions taken by the company in the future under this paragraph. Furthermore, this paragraph offers no defense against prosecution for any infractions committed by any current or former officer, director, employee, shareholder, agent, consultant, contractor, or subcontractor of the business, staff, representatives, and advisors on any issue pertaining to bank infractions. Secrecy Act, regarding which the company possesses knowledge or which the government may request information. In addition to the aforementioned duty of accurate disclosure, the company shall, upon request, furnish the government with any document, record, or other tangible evidence pertaining to any such violations of the Bank Secrecy Act that the government may question the company about. In response to the governor's request regarding any matter pertinent to its examination of potential Bank Secrecy Act violations. In connection with the company's operations, or any of its current or past subsidiaries or affiliates, the company shall appoint competent staff members, agents, or attorneys to furnish the government with the data and documents mentioned in above on the company's behalf. Furthermore, it is acknowledged that the company is required to provide accurate, comprehensive, and genuine information at all times regarding any matter pertinent to the government's inquiry into possible Bank Secrecy Act violations involving the company's operations. The company shall, to the extent feasible, guarantee that the government has access to all of its current directors, officers, employees, agents, and consultants for interviews and testimony in the United States, whether through its parent company or any of its current or former subsidiaries or affiliates. This investigation include, but is not restricted to, sworn declarations made in federal trials or before grand juries, as well as if, during the duration of this agreement, the government decides at its sole discretion that the company has violated this agreement by A. Committing any felonies under U.S. federal law after this agreement was signed, B. At any point giving false, incomplete, or misleading information in connection with this agreement, will be imputed to the company for the purpose of determining whether the company has violated any provision of this agreement, including the Constitution, Rule 11, F, of the Federal Rules of Criminal Procedure, Rule 410 of the Federal Rules of Evidence, or any other federal rule that states that statements made by or on behalf of the company prior to this agreement, or any leads derived therefrom, should be suppressed or are otherwise inadmissible. It is further understood that the government and the company may disclose this agreement to the public. This agreement is binding on the government and the company, but it expressly does not bind any other federal agencies, state, local, or foreign law enforcement or regulatory agencies, or any other authorities. However, the government will bring the company's cooperation and compliance with its other obligations under this agreement to the attention of such agencies and authorities if requested to do so by the company. All of the terms of the agreement between the government and the company are outlined in this agreement. No modifications, additions, or alterations to this agreement will be enforceable unless they are made in writing and signed by the company's attorneys, a lawfully appointed representative. The corporation known as Ripple Labs, or XRP, is based in San Francisco, California, and is registered in Delaware. The companies that came before Ripple Labs enabled virtual currency transfers and offered services for virtual currency exchange transactions. As XRP, known as the Ripple Network's currency, is pre-mined, indifferent before it was distributed, in contrast to several other virtual currencies. After Bitcoin, XRP has the second largest market capitalization among cryptocurrencies as of 20Y5. A fully owned subsidiary of Ripple Labs was established in South Carolina. July 2, 2014, saw the name change of XRP Fund 2 to Currency Ecosystem, XCHI-1 GERS and administrators. Guidance specifies that, in accordance with laws, exchangers and administrators of virtual currencies are money transmitters, a kind of MSB, and must thus register with FinCEN as money service firms. More specifically, the guidance defines an administrator of virtual currency as an individual or organization that is engaged as a business in issuing, putting into circulation, a virtual currency, and who has the authority to redeem to withdraw from circulation such virtual currency. An exchanger is defined as an individual or organization that is engaged as a business in the exchange of virtual currency for real currency, funds, and other virtual currency. Exchangers and auditors are both MSBs that, barring an exception, must register with FinCEN. Under the Bank Secrecy Act and its accompanying rules, MSBs are subject to certain additional requirements regardless of whether they have registered as needed. MSBs are required by the Bank Secrecy Act and its implementing rules to create, execute, and uphold an efficient written anti-money laundering AML program. No plausible explanation for the transaction after considering all relevant information, such as the transaction's history and potential goal, or entails using the MSB to assist illegal behavior. MSB must implement Know Your Customer, Now Your Counterparty procedures as part of their risk assessment and risk mitigation plans. These procedures require the MSB to comply with their AML program requirements regarding foreign agents or foreign counterparties and assess the risk involved in providing account-based or transactional services to customers based on their identity and profile. FinCEN. Interpretive Release 2004, Anti-Money Laundered Program. Requirements for Money Service Businesses.